Article 77 of the Family Code of the Philippines states that the marriage settlements and any modification thereof shall be in writing, signed by the parties, and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry where the marriage contract is recorded, as well as in the proper registries of property. These are the key points in this article. First, marriage settlements. Second, requirements for validity. And third, the registration. So let's talk first about marriage settlements. So when we say marriage settlement, it is a contract between two individuals intending to marry. It specifies how their property will be managed or divided during and after the marriage. So points to remember for marriage settlements. Number one, under the family code, the requirement that an antenuptial agreement must be in writing is mandatory, not only for the purpose of enforceability, but more importantly, for its validity. An oral marriage settlement, therefore, is void and cannot be ratified by any claim of partial execution or absence of objection. Two, it must be signed by both parties, so both spouses must sign the agreement voluntarily. 3. It must be executed before the marriage. The agreement must be executed before the marriage celebration. 4. Modifications also require the same formalities. Any changes to the agreement must likewise be in writing, signed, and made before the marriage. So let's talk about the registration. To affect third parties, settlements must be registered in A. The local civil registry where the marriage is recorded, or B. In the property registries of property, such as the registry of deeds for real estate. Why we need to register? First, for protection of spouse. It ensures clarity on property rights, financial obligations, and inheritance. Second, for third-party protection. Registration informs others of existing agreement. And third, for legal validity. Unregistered settlements may not be enforceable against third parties. So when we say third persons, these are individuals or entities outside the marriage, such as creditors, business partners, or anyone dealing with the spouses or their property. When we say prejudice means to harm or disadvantage their rights or interest. So when we talk about not prejudice third person means that third parties' rights cannot be negatively affected by private agreements or marriage settlements unless those agreements are properly registered to provide public notice. So for example, spouses A and B prior to their marriage executed a valid marriage settlement stipulating that of the three real estate properties of B located in Quezon City, San Juan, and Caloocan City, the properties of B located in Quezon City and San Juan shall be excluded from their absolute of property during their marriage, but all the other properties of B, including the real estate in Caloocan City, shall be included in the community property. Because the property relationship is governed by the absolute community of property, this means that the property in Caloocan City shall be co-owned by A and B during the marriage. Had there been no marriage settlement excluding the property in Quezon City and San Juan, such property would have also been co-owned by A and B during the marriage. So prior to the marriage, B borrowed money from Y. The loan was used by B personally and it did not benefit the family of A and B during the marriage. When the debt became due and payable during the marriage, B defaulted. After obtaining a favorable court judgment against B, can Y, a third-party creditor, execute on the property located at Caloocan City, now co-owned by A and B, to satisfy the debt of B? If the marriage settlement of A and B is exclusively registered, Y will be prejudiced. This means that Y cannot execute the property in Caloocan City by having the court sheriff sell the same to satisfy the judgment debt because, even if the Caloocan City property were exclusively owned by B, at the time the loan was contracted, such property during the marriage become part of the absolute community of property, which is liable only for community debts. Such property cannot be liable for the exclusive obligation of B, especially when B still has sufficient separate properties, such as those in Quezon City and San Juan, that can be used to pay his exclusive debt. If the marriage settlement of A and B is not registered, Y can execute on the Caloocan City property because he will not be prejudiced by the marriage settlement. In effect, the Caloocan City property can still be treated by Y as exclusively owned by B for the purpose of paying off the judgment debt.